probably complied with. The procedure simply is allow the National Judicial Council to look at it on the merit. They are also in a position to say whether or not it's one of those matters that should come before them. Unlike a situation where you had another arm of government jumping in and coming to take a decision in place of that constitutional organ.
Speaking about jumping in, but I'm sure you've also heard this narrative where they think that, wait a minute, but if it was up to the CCC to determine it, the CJN himself, having also given a landmark judgment in that context, why was he going from one high court to the other, seeking certain judgments as well? Does that also follow?
Now, these were interventions probably by some concerned stakeholders who felt that in a country like ours, there was a threat to our democracy in the form of trying to forcefully remove him from office. And so those judicial interventions were sought, not necessarily by him, but by certain non-governmental organizations or individuals who felt concerned. Now, the merits of whether or not those persons or bodies had the virus to approach the courts was also one of those issues the courts will have been able to determine. CCT will have said, oh, you bringing an order from the National Industrial Court is not binding on me, but leave it to the court to reach that conclusion, and not from outside that, body that has invested with the judicial powers.
What does it mean to the body of lawyers now that the CCT has adjourned this trial indefinitely?
By implication, we have a situation in our hands where, technically speaking, the CJN has been removed or suspended, and that is the subject matter before, or one of the issues before the Code of Conduct Tribunal. Now, are you still going to go back to CCT tomorrow to say whether or not CJN should step aside? Because you already got him stepped aside, which is a matter that is pending before the Court of Appeal now. Now, we won't go into the merits of the appeal, but the implication is technically there's nothing before the Code of Conduct Tribunal today until the Court of Appeal reaches a decision to say whether or not you have the powers to continue with the trial.
But didn't NBA, by extension, touch on the merits of the matter when they did ask that they recall the CJN?
Well, if you are asking that the removal was unlawful, in the eyes of the law, you are saying, let's go back to where we were.
But that's part of the matter.
That is not part of the matter in this circumstance, because now, let's not forget that we'll be laying a very bad precedent for, if this goes through, I can bet you that very soon you'll see governors who will probably take orders from magistrate courts and suspend and remove from office the chief judges of various states.
Yeah, can they do that? What laws would they rely on?
They will rely on this same procedure. If this goes through, it becomes a precedent. Well, simply they will say, oh, there are allegations against the judge, and this is not the matter that should go before the NJC. And as such, there's an order exparte from the magistrate court asking that the CJ step aside, and then the governor acts on it. And then the matter now brings us to where we are today, whether you rightly asked him to step aside or not.
Do you think that, according to the President's submissions, that the war against corruption cannot be truncated, and that this case, for instance, is one that must be looked in that light also? Do you agree that this case is a case of corruption beyond what meets the eyes?
Well, I totally disagree with that view. The NBA, in any situation, is in tandem with the government that is interested in fighting corruption, because that's our collective duty as Nigerians. So NBA is, in fact, in the lead in that fight against corruption. But then, in fighting corruption, are we transparent? Are we selective? What are the yardsticks we're using to fight corruption?
Due process.
Due process, which is not followed in this case. Now, assuming you wake up tomorrow and you walk to court and get an order exparte to say the president of Nigeria has been removed from office, and you go ahead to do that, bypass the National Assembly and all that. Perhaps if there's an allegation of corruption against the executive. Now, that is not due process, because the Constitution has stipulated the mechanism, the method by which you can take certain steps.
Can the NBA ask that the CJN be recalled when most of these matters bordering on the suspension of the CJN is in court?
Before we got to the point of whether or not the CJN is the CJN, he was the CJN until another Justice of the Supreme Court was sworn in. Now, NBA is insisting that you take us back to that point before you came to the tribunal. You came to the tribunal, there was an application to ask him to step aside. That application has not been taken. So let's go back to that point until that decision is reached by the tribunal. Then you can say NBA is perhaps asking...
So what if some argue that by the friction of time, look, that can't happen now, because if it's in court, what you're asking for, you're going to tie the hands of so many other people.
Well, if that is the view...
the CCT is adjourned indefinitely.
If that is the view of any individual, that is not what the Constitution says, because the Constitution is very clear. In the eyes of the Constitution, the CJN remains the CJN.
But there's really nothing you can do. NBA cannot do anything. Nobody can do anything this time, because this case is with the CCT. And it is not presiding over this case. It is indefinite. No one can do anything until after the elections. What will you respond to this kind of, to this line of narrative?
There is everything we can do, and we must all come together and remind the executive. Our protest is one of those methods to say, look, let us get it right. The whole world is watching us. A few days to our election, we're taking various steps that are strange.
Do you think you can really achieve anything, even with your 2 days strike?
Hopefully, hopefully. Because we are attracting attention, first of all, to say we are very displeased with the method. The executive arm had invaded our judicial arm.
You think that the executive will budge?
Well, whether or not they will budge is another issue altogether. We're going to insist that we get back to track.
But you know, if I could also draw on that comment from the minister and the interpretation that some people have given to it, they just felt that what was the president supposed to have done? If you have an ex-parte saying something be done, if you act on that, can you be blamed for acting on that, or you blame the CCT for giving that judgment?
But then, why are we selecting the orders we obey? In the same country, there are so many orders that has not been obeyed by the government.
Yeah, but
and then suddenly, we wake up and we now want to obey orders.
Okay, so in this case then, are you asking that you should have disobeyed the order?
Well, was it an order asking the president to suspend the CJN in the first place? The order did not say suspend the CJN. It says, CJN, you are advised to step aside. Now, that order itself was not even served on the person so advised. So, were you complying with that order?
Yeah, because if you argue that we select the judgments you obey,
yes,
you're suggesting that you might as well have ignored or overlooked this one. That's the way it comes across.
Well, we must be transparent in whatever we want to do. Assuming the government had the attitude of obeying court orders, we'll be very comfortable with it, that yes, it's in line with obeying the orders that have been rolled out from our courts. But here you are, so many orders served on government duly.
Yeah, but it's the first time to always change and look the other way.
You don't look the other way, especially when it has to do with another institution. You're already taking away the independence of the judiciary by invading the gates of justice.
No,
to say
the president says that he's relying on an ex parte order that gives him the powers to suspend the CJN.
But if you read the order itself, did it say, Mr. President, remove the CJN? That is the question.
No, he didn't remove the CJN. He suspended it.
Okay, the order did not say, Mr. President, suspend the CJN. The order simply says, CJN be advised to step aside.
And when he doesn't?
But have you approached him to say step aside? Have you served the order on him?
Who was supposed to approach him?
The order, if it were served on him, to say there's an ex parte order against you, advising that you step aside, until you get his reaction to that order, you won't be able to reach the conclusion that he may not want to step aside. But you took the order itself to the executive and said, look, this is an order served on the wrong party, to say the man that has been asked to step aside.
So who's supposed to have effected this order?
Assuming you got an order and the order is itself valid, serve it on the party that is interested, that is going to be affected by the said order. In this case, it wasn't even served on the CJN. There's no record to show that it was served on the CJN.
Because the CJN himself said it wasn't served on him.
Well, the onus is on them to show that the order itself was served on him and he refused or accepted to step aside.
But did the NBA verify that it wasn't served on him?
Well, verification, there are lawyers that are representing the CJN. Perhaps this matter will have come up if...
Yeah, but did any one of them actually say that it wasn't served on
Not to our knowledge. In fact, the exparte order itself came out for the first time in the hands of the executive.
But what is normal procedure? If this happens, we understand that the procedure is rightly or wrongly. You have to go and seek it, you have to vacate it.
There are certain orders themselves that, what if the order itself is probably made without, like in this case, the court had adjourned, the tribunal had adjourned.
Yeah, that's why I say rightly or wrongly, whichever way they obtain the order. What lawyers or what your colleagues have always said is you have to vacate it before you take subsequent actions.
Yeah, but why did you hurriedly take the order on the same day and implement it?
But you're the same lawyers who advocate that the system should be fast-tracked.
Fast-tracking is a matter of procedural law brought about by the Administration of Criminal Justice Act. Now, but even at that, what does the Constitution say? Fair hearing within a reasonable time. It did not say bring the man today, hang him. Okay, take a case of murder, for example. A man who has even confessed that, yes, I killed Mr. A. The law still enjoins the judge to record a plea of not guilty so that the prosecution will still establish and say, these are the ingredients to justify that you indeed committed the offense. Now, in this case, we haven't even gone to that.
Yeah, but still speaking on the procedure, isn't the procedure to vacate that, rightly or wrongly?
The procedure would have been to have that order vacated, assuming the order itself even said what they had done. But I'm saying here that the order did not say, Mr. President, suspend the CJN. The order says, the CJN, you are advised to step aside.
But you cannot have a vacuum, even though he steps aside.
But have you even served the order on the CJN? You have not even served the order on him.
Which is what we're saying that, look, just as you said, you're not sure those represent, there isn't a concise or clear word that he's not been served. So we're just wondering what did they then build on, because there's so many information flying out there.
Information flying out there, well, the processes of court, there is a method by which you can confirm that they have been served. There must be an endorsement. Unless you can show me an endorsed copy that this order was served, I still maintain the point that it was not even served on the CJN. So the issue of whether you want to take steps to vacate the order or not, does not even, but the man is not even aware. As at the time you had this, that there was an order.
So, but what about those who describe this as a typology of self-help? If the NBA seeks that they reinstate the CJN without the process, without this exparte being expired or being vacated?
NBA itself is asking that you follow due process. NBA is not resorting to self-help.
So is NBA themselves following due process?
Due process, yes, and that's why we have come. We have not carried arms. We've not gone to say you must bring the man back today or all that. We are saying simply,
due process doesn't mean you have to carry arms.
We're saying simply, reinstate the CJN. If you want to remove the CJN, the constitutional provision is very clear as to how you can go.
Let's go to break. There's some few more issues that we need to raise. We'll do that in just a moment. Don't go away.